accordance with Master Laws, Chapter 48, Section 11, notice I hereby given that the Open Zoning Board of Appeals will hold a continuation of a public hearing on Tuesday, April 2nd, 2019, at 7 p.m. in the Housing Building at 697 Main Street, Open Mass to hear and act upon the application of Still River Road Development LLC, and Shoney's and Farrell PC. The applicant is seeking a comprehensive permit for proposed housing development to be located in Bolton's residential zoning district on Still River Road, identified on Assessors Map 88, parcel 32, approximately 6.68 acres. The applicant is seeking a comprehensive permit to construct 8 units home ownership housing pursuant to Master Law 40B. The development consists of 4 2-unit duplex-style buildings located on 2 lots each, containing 2 duplex buildings. In accordance with Master Law Chapter 40B, the development will contain 2 affordable units. So, with that, the last meeting we had a couple items. One administrative was the allowance of a 2-week extension by the applicant so that we could have tonight's meeting, maybe work on the document. So we have a letter from the applicant, from the Shoney's granting that. That's in the public record. There was a question at the end of the last meeting with regard to the height of the buildings based on the depiction of a rendition that we had. So one of the abutters, I think it was the Picarellos, had a question on the height, and we received a response talking about the level on the land and the height of the building, 3-story buildings, and the conclusion, at least from the applicant's perspective, that there's no height variances being requested. The fire department didn't identify any concerns, so they believe that it's a matter that they believe is, at least it's noted what it is. So that letter's in the file. We did receive a letter, well, this was to the town of the Bolton Conservation Commission from the Department of Fisheries and Wildlife to the Conservation Commission regarding the development. And in effect, on the wetlands impact, compared to the original order of conditions on the property, with this new project proposed, at least their interpretation is it won't impact the negative, won't adversely impact or affect the resource area habitat, assuming it all stays confined to that same footprint. We had a letter.
This letter also talks about individual issues as well. Basically the same thing.
Okay, right, so it similarly concludes with regard to the species that there will be a prohibited take based on again, if the project stays within the same footprint as it's currently proposed. We had a letter from the planning board where I guess Eric went to a meeting with the planning board and they discussed the alternate layout of building units 1 and 2, correct?
Board of Health.
Board of Health.
Because
you wrote it from the planning board.
Right.
Sorry.
Sorry.
And the Board of Health identified a preference to the alternative layout based on the septic tank and pump chamber being monolithic and the septic tank being retested, correct?
Correct. Yes.
What's that?
Correct.
And then we have a letter. Is this new, this letter from?
You know, I don't know. I received it recently, so I included it in your packet. It's from one of the abutters. They had reached out to Natural Heritage last year.
Right.
So I just wanted to make sure that it was in the record.
Okay, so that's from June 4th letter. Again, we had the Picarello's letter and the response from Dr. Shoney's.
And then I just included figures from Bolton's open space and recreation plan, just to make sure that that's also on the record that shows the sensitivities of the property.
Mhm.
So,
That's,
those figures there, correct.
so with that, I guess we should, the biggest order of business items, we were, said, we were gonna try to focus on reviewing the waivers that are requested in the decision document, and coming to a conclusion whether the individual waivers should be granted or not granted, and then should we get to the waivers, then we can procedurally take a final public comment, and close the public hearing portion, and then vote to either approve the decision with conditions or to deny the permit application. So that's sort of the roadmap we're going down the road today. So I guess we have this new document from the applicant today, this re-summarization of the waivers, is that correct?
Yes, Mr. Chairman, we just wanted to compile them for you. There's nothing new in here. This list has been submitted to you in the past in various forms. However, I do want to point out that this list assumes that you would choose, that you would prefer the alternative location that we presented at the last meeting, and which was the topic of discussion with the Board of Health. And in reviewing the Erica's email on that meeting, it seemed to us quite clear that at least the Board of Health would prefer that alternative. So we drafted this list assuming, so what we ended up doing was, correct me if I'm wrong, we ended up taking away one waiver request with respect to the setbacks from the wetlands, and then put in a waiver for the setback for the septic tank. Is that?
Well, the waiver for the setback to the wetlands was adjusted for the alternative layout of units 1 and 2. And then that requires in turn the relocation of the septic tank that we talked at the last meeting, which is a waiver. And the Board of Health memo I saw spoke in favor of that.
So if the board's not inclined to select the alternative, then we would go back to the list that we gave you prior to the last meeting.
I think that we would take the guidance from the discipline experts, right, the Board of Health on that aspect, so we can conclude with that list. So the waivers are structured around pretty much conservation, wetlands, and then Board of Health, and then zoning. So with regard to the wetlands, I mean, for all of them, but the whole project's within the 100-foot buffer area, right?
There's 700 plus or minus square feet that are out of it, but the vast majority is.
The vast majority is within. And so all the waivers that you have here for dimensional waivers, they're all within the is it the upland resource area? Is that how?
The Cora area, the upland, the adjacent upland resource area, which is
So all
25.
within the buffer area primarily, they're all within that other upland. But the state requirement would be, they meet the state requirements.
They need to meet the Wetlands Protection Act, the requirements of the Wetlands Protection Act.
And that is less restrictive than our bylaws.
Yes.
Yes, so the crux is, like, for me, well, me personally, as far as looking at these, I'm trying to get a sense of how the applicant can ensure that these requirements will protect the property and the surrounding properties. Without, you know, how they'll protect that property to the extent that Bolton is trying to protect that type of property by our bylaws. So, I don't know if that was clear enough, but, because in general, when I look at them all individually, and with the feedback we receive from the Conservation Commission, other boards, planning board, selectmen, you know, in the uniqueness of this property, there's a concern that even these waivers, while they may meet state requirement, they aren't in the best interest of the town. So I'll need some enlightenment as to that assurance. Can't do that. So let's just start with the first waiver that speaks about allowing alterations within 25-foot wetlands and to allow alterations within the adjacent upland resource in accordance with setbacks below to allow the construction of the project. So from the board, anyone have a comment on that first? My inclination is that the conservation doesn't believe that we technically should allow that. That's my opinion on that.
I have problems with a lot of these that I've read where they're overriding the town's wetlands protection regulations, and I don't see the need for it, quite frankly, because my blanket take on it. How does it benefit the town? You know, we have no sewer system, we don't have no public water system, and if this fails, what will be the result, and who's going to be taking care of the problem?
Right, so we've had feedback from the applicant that, yes, at some point it turns over to the homeowners association and they take care of it, but to an extent.
But they're not going to be happy.
No, that's probably true, but, you know, so.
I mean, take it by themselves, like a little bit at a time, shave off a little here, shave off a little there, but the cumulative impact, I mean, if you look at the property and you also look at where it sits and how it connects the other pieces, I just, you know, you can shave off a little bit here and there, but that's the cumulative effect on that piece of land and that piece of property at a very sensitive spot, right between conservation lands and the river. And you've got all kinds of traffic going through there, you know, with the vernal pools, with everything. It just, you know, you can make a case for shaving off a little bit here, shaving off a little bit there, but it's a cumulative effect that really concerns me.
Well, the other thing I would say is the abundance of waivers necessary to shoehorn this project into this lot. We deal with them typically, you know, there's a few waivers, usually offsets to, you know, property lines and that sort of thing. But, you know, this is an abundance of.
Well, I think it's part of them because, you know, some of the waivers, I mean, the first one is basically this is allowed for the construction part of it, but then the next 7, the next 8 are specific to the 8 units setbacks, you know, so if there's only one unit, they'd have one waiver, you know, but, you know, so it's complicated there, but I would think a decision on one or all of those would be similar, so if you know, if we're saying, no, we don't want to allow development within these parameters, and we, you know, didn't allow for the first one, and it would be probably similar for those 8, and that sort of takes those out, or at least moves it on to the next sort of section of the, because you deal with some unit setbacks, then it goes to wetlands, and then I think it goes to septics, or edge wetlands, and things like that, so probably in groups if necessary.
And the other thing I would say is, anybody else building a private residence would be required to abide by the town's, conservation bylaws. I mean, they could apply for a waiver here and there, but I mean, generally, when you build a house or develop a piece of property, you're supposed to abide by the more restrictive regulations we have in town. And I just don't see why the intensity of development is necessary on this particular site.
Well, but for the fact that it's coming to us as a 40B, which
Right, I understand that.
which allows for that sort of, if the project were to be approved, that density bonus, because technically we're getting some level of affordable units, but that's,
We have 40Bs in town. I mean, I don't think we've ever had quite as many waiver requests.
Well, they're usually, detailed, but yes, the number of units sometimes broaden the number of waivers.
But not with wetlands
Yeah,
and.
right, because
They're
it's
offsets,
a
they're
unique
property
site,
lines.
we don't have a site where it's all, close to
Right,
that.
slopes and other type of.
Right, right. So if we were to just, make a disposition on this first set of them, personally, of the mindset to uphold the Conservation Commission's recommendations that we don't grant the waivers within, within the proximity of these, this upland area. But that's just my opinion.
I would agree.
I would agree.
Yeah.
I don't think we've seen a project with this level of environmental sensitivity, and that coupled with the vast number of waivers and exceptions that we're being asked to act on. So it's too much.
So then that would apply from, in effect, if we number this one, the first one, and then the units 1 through 8. I guess if we use talk to one list, this list here, as I said, everybody match this to here, maybe. That's what we have that too, so. Yeah, that's good. This one here, is that, so that's the start to it then?
Well, these are
All under that, those are under, okay, so that's all under the first 8. So the first, so that's first 8, we're going to conclusion that we would, no, on the
I
discussion.
would say yes.
Yeah. Yeah.
So then we go to the next 2 deal with the proposed wells on lots 2B and then on lots 2C. And then it's asking for waivers to be allowed 41 feet from the edge of the wetlands and 60 feet from the edge of the wetlands. Did we get any feedback from the Conservation Commission, any view on those, Erica? Is
On the
that
well
similar?
location?
On the wetlands, edge of the proposed wells,
I don't believe so, no.
so it'd be all consistent with
No,
that.
they only provided feedback on the wetland bylaw waivers.
Mhm. Well, those was part of the overall waivers? The bylaw?
Oh, I'm sorry,
Yeah.
yes.
Right. So they didn't.
You're correct, yeah, so they actually, they may have weighed in on that. They had issued a letter on March 19th where they had given some feedback on each waiver to the board. I think we touched upon it at the last meeting.
So is it this, it would be this, the same vein that you still would prefer that the development not be within the same situation, still within the 100-foot buffer, but is it all within the sort of operating resource?
Do you have that one?
I don't think they
didn't specifically.
didn't address it
address
specifically, now that I
so,
looked at the letter.
So I guess it'd be a similar factor as far as consistency with the others is that then we would not to, we would have a similar disposition.
The primary issue is the same, it's
Right.
measurement from the edge of the wetlands.
And if we're trying to protect that same space, then it would be similarly concluded on. I agree.
Yeah.
Okay.
I mean, if we're gonna disallow 48 feet from the edge of wetlands and 41 feet,
Right.
yeah.
And they're all, or even 36 and others,
Right.
so.
I mean, here's 60
Yeah.
even.
Mhm. So would that be no on those two items? With regard to the wells?
You know?
Was that,
Is it in there?
there's no on those. Then we have the sewage disposal system, so reaching on lot 2B, you know, there were 50 feet from wetlands. And then the disposal system on lot 2C, the 56 feet from wetlands. All of these have that similar dimensional issue. And I don't see any particular guidance that so, I mean, it could possibly be inconsistent to then just, you know, have a similar result on all of these, as far as,
Yeah.
going to go within that parameters there, it would seem like they would still follow here as well.
Yeah.
Anyone have any counter discussion to that?
This isn't the same though as what the Board of Health is commenting on, right?
What is that?
They're just telling me what they prefer. The applicant meets Title V, providing 41 feet. And they're amenable to granting waivers
To which particular waiver?
to allow
Right.
leaching facilities to be located within 30 feet of each other.
That's different though.
Okay,
I think that's under the Board of Health.
Right.
Separate.
okay. No, yeah, I agree. I mean, if we're saying, you know, on the other, the distance for the other ones, then this doesn't make any sense either. I mean, even in and of itself, if we were okay with the units being that close, I'm not comfortable saying yes to the sewer being that close, the septic. Just-
So is there a general conclusion that any of these dimensional requests through the remainder of this list, then we're considering this option of all?
Right.
So let me know. Is that right through the waiver of the, to allow all definitions of wetlands apply? Did that get right down there and just have the dimensions? And then it makes sense.
The only one that doesn't specifically mention wetlands is the naturalized scrub and forested habitat.
It's a habitat restoration.
Well, is that restoration or is it just alteration to turn it into something different than it is now?
Mr. Chairman, I think I can answer that.
Okay.
I believe as part of their review of the project, correct me if I'm wrong, Natural Heritage suggested that we naturalize, do some
Okay.
plantings in that field area so as to improve the habitat
Okay,
quality in that area.
okay,
So that was a requirement of their letter.
okay.
And you're asking for a waiver because it's within the buffer?
Mhm.
Okay.
I don't really have an issue with that.
What's that?
I'm fine with that.
So now what do you say,
Yeah.
grant, sort of, the
Yeah.
on that one?
Yep.
Okay. And how about the way the wetlands bylaw regulations to allow in the Division Wetland Protection Act to apply? Pretty sure what that does.
Basically wipes out the whole regulations then.
What's that?
It's the way wetlands bylaw regulations allow only definitions that are in the state.
Yeah, I'd say that's a
Yeah,
no,
and we wanna
because
uphold
that's
the-
the same
the-
basis
right.
that we're trying to uphold the wetlands issue.
Right.
Mhm. So then we move on to Board of Health requirements for subsurface disposal of sanitary sewage. So we for the Board of Health letter, they address these 1, 2, 3, 4, 5, 6, Board of Health. Or 7, which ones are specifically addressed here?
Tank closer to 50 feet.
So where's that letter? So, so alternate layout. So is that on, which one is this? Is there only 2 waivers there that they're specifically given here, or, because that's more of a condition that will be monolithic and that the pump chambers be monolithic and that they'd have leak testing, but that's one of the condition.
So they were amenable to the last two waivers on that list.
We'll reach it.
The last two?
To allow the leaching facilities be located within 30 feet of each other, and then the septic tanks to be within 50 feet of the wetland.
It was,
With those conditions.
With those
right,
conditions.
right, yes. So, with conditions. 27. Okay, so on those, if we have a recommendation from the board on those, we could, again, the technical resources for the town on that are subject matter experts, so I could see granting yes on that in my opinion. But
On which one?
on the last two on the list here, because it matches up against their recommendation on the alternative. With the recommended conditions that are there, so that would get feedback. I'm good with that. Ms. Stoner?
Yes.
Yes, yes.
Yeah.
Anything?
On the last one, I'm not comfortable with it because that specifically references the wetlands. So I think to be consistent, I would say no to that.
So on the second to last one, yes, and the last one, no?
That's the way I would approach it. Yes.
So, what's your opinion on the second one, Katie?
Well, I mean, the condition for this seemed to be that they're saying, okay, well, you know, if we allow the septic tank to be closer than 50 feet, it's gonna reduce alteration to 25-foot no disturb jurisdictional area. So if we're taking that off the table, then I would agree with Andy, that I'm okay with the first one, but the last one,
So
yeah,
the fifth
no.
one would be yes, and the second one, you kind of say no.
Yeah.
Okay.
What do you think, Bradley?
Yeah, I think that with the wetlands, the 41 feet, we should.
So, the majority, then that would be no. On that one. And they didn't opine on the other 1, 2, 3, 4, but in the past, they've recommended that we don't approve those
Correct.
waivers, correct?
Correct.
I would say 3 and 4 are no, because again, specifically related to the wetlands issues.
Mhm.
1 and 2, if the Board of Health was recommending no, I would support that.
Mhm.
So those would be no, because we haven't, in the past, that's what they've concluded. And, Bolton well regulations then, waiver of section 4.1 entitled well regulation requirements is requested, most specifically the following from section 4.1 is requested to allow lot 2B well to be located within 150 feet of a leaching facility in soils with percolation rates of 2 units per inch or less, 120 feet provided. Second.
Right, do you mind just backing up for a second? I apologize. I missed the first and second waiver on the Board of Health list. What were your decisions on those?
So those, the first two were no, the second two were no, the third one, the fifth one was yes and no, last one was no.
Thank you.
And this Bolton well regulation, is that under the Board of Health as well?
It is.
Did we get any feedback on that?
We did not.
We did not. So that would have been covered under the original recommendations to not allow that over?
Is this saying that it's 120 feet?
Yes.
And that doesn't have to do with wetlands, it's just well location.
It's well location for the septic, leaching facilities.
Does that have any relationship to the fifth one on the prior page? Or does it mention the facilities? No. So, I guess in that vein, to be consistent with then their overall opinion, if we don't have some,
What's the state requirements on that?
For the well,
Yeah.
it's
100 feet.
100 feet.
It's 100. I'm okay with that one.
Which one?
the last one on the water, the well location one, the one on the last page.
Yeah.
I mean,
You said there's no opinion from the
Right.
government.
Well, right, there's no opinion to grant it, you know, the original feedback would be to not grant it, not grant it, but I don't, technically that's out of my purview, so I just, it would be consistent in following, you know, if we in specific.
Yeah, I would stick with the town regulations.
Okay, so that would be a no, is that?
Yeah.
So, I mean, the majority, we recognize that, Brian mentioned that, you know, he'd be okay with that one, but, you know, overall, the board is, okay, so then we go to the zoning. So, while these are fairly normal, requirements with regard to, you know, 40Bs.
I would grant the first one.
What's that?
The first one, I think, would be grantable, yeah.
As what the church proposed. Right, so if they had a viable project, then that would be a consistent 40B.
Yeah.
Mhm. Where the tone of most of these are going as a no, would it make sense to say that, yeah, you can have multiple units on, multiple structures on the site if we're not heading that way, it looks like. If they can't get all these waivers, then they probably can't have those multiple units, but.
Right.
But in general, it would be a yes.
Yeah, that would be a yes.
Okay. So the other yard setbacks, to allow sideline setbacks interior to the lots that are being created. From as far as, you know, having setbacks and feedback we had from, we didn't have any issues from say, fire or anything saying that you know, too tight or too close, so we could say yes on that. But that's up to the board.
Yeah, it's yes.
One building per lot, an exception is requested to allow for multiple structures on the lot. Again, that would be, I think that's a typical 40B, is if we were going to, because you were to get the affordable housing component of that, but, you know. so-
Ties in with the first.
Right,
Similar to the
all these
first.
sort of tie in
Yeah.
as far as lot shapes and exceptions being requested to allow to have a shape factor of 4 where 5 is required, so again, that would probably be this from a zoning perspective.
Yes.
Yeah.
And driveway and parking, to allow for shared driveway to access the site.
Yes.
Now, is that specific to 8 dwellings on 2 lots? Is that part and parcel of this waiver? That if we say yes, then it's a yes to 8 buildings on 2 lots?
Versus just a
Versus
multiple
multiple,
structures,
right.
right?
Yeah, you're right.
I mean, I'm inclined to say no on that one.
Only because the number of units is specified.
Mhm.
Right.
Yeah, that's fine with me. I have no problem with shared driveways.
Right, yeah,
in
yeah,
These
yeah.
type of projects.
Mhm.
Right.
So if we alter, well, it's their waiver request, but,
Oh, we've already said
the
multiple buildings. We've
multiple,
also,
right,
yeah,
yeah.
we've already waived the
Right.
1 lot,
Mhm.
1 building per lot.
right,
So-
in the project, it has defined scope
Yeah.
is that,
Right.
is what it is, so.
I'm just not comfortable specifying the
Mhm.
exact,
Yeah.
that exact number on
Mhm.
here.
But it's, you know,
It's
it's
what the, it's what the project is.
It's scope,
Right.
the scope of the
Right.
project, so.
Right. Yeah.
Currently, so. So,
So as written, I would say no, then,
so,
because it specifies the number of units. 12.
only I hesitate only because that's, the whole project is saying that that's what the, the scope of the project is, it's in, so.
I mean, we've had other 40Bs where they did change the number of units.
Mhm.
And, I mean, all the
At some
40Bs that
point.
I've ever been on, they've always changed the number of units. They've always been flexible with this, so.
Right, right. This, right.
So you say if we say yes, then there's no flexibility for them to change.
Yeah.
Do you have any opinion on that, David, as far as like the language of that, where the project is proposed as a 8-unit development?
And it's not specifically called out in the other waivers that, at that last one, that allow this number of units. Does it have to be as clear as that, or does it have to be changed?
Are you speaking, excuse me, with respect to the prior 5
The 215-17.
requests for waiver, or that very last
The
request?
very
Very
last
last one.
request.
Yeah, the very last request is specific
The
to,
project, right?
to the project and 8 dwellings, as I understand it. I mean, Mr. Duchesne's confirmed me.
So if the project were to go change, then the way it would be, it would go acres.
National Heritage said it was going to impact the species on the land.
So, any final feedback on that? Yes? Because if the size change, it doesn't mean that it's, we're approving that, we still have, ultimately have to vote on that decision. The project's over. So we have a no, and a no, and a yes? No. Yes, so why don't, we'll put that as a yes. It's majority, but it's not, there's.
So it's majority, not absolute.
Well, I think as far as to come to this list,
Okay.
we have to vote on a decision at some point. But
Right.
I think just to get a conclusion on whether we waive or not,
Mhm.
that,
Mhm.
right, it's not like we're voting individually on these, so that if the overall board, 3-2, so that was yes, there's nothing to say, that's a yes.
So my suggestion, just for clarity of the record, Mr. Chairman, would be to group these waiver requests where you have unanimity of opinion or the same opinion for the board and take, it's okay to take these motions in groups, I think, but I think you want to do motions for these waivers, particularly where you have the difference of view among the board members on certain waivers. So for example, if you're, if the board for a certain group of waivers says yes or no, then I think you need, since the board does not feel the same way about all these, I think you want to vote them independently, except where the board feels the same way on each of the waivers. So for example, if the board all feels the same way on waivers 1 through 8, then I think you can take a single motion on that. But otherwise, I think you should do individual motions for those waivers.
So to recap this, that we would go back and do that type of procedure.
I think for clarity of the record, you want that.
Okay. All right, so we got our pass-through then. Did we address this? Did we address that? With this first one?
The groundwater protection?
We addressed number 1.
Oh.
Okay, I thought that all fell under here, okay, groundwater. So let's go back to that as the first one, and then. Oh, that's right.
Do we have a copy, section 147, the groundwater protection?
I don't have it in the packet. Pull it up on my phone.
Is that 147 you turned correctly, right?
Yeah, you have it.
Well,
Does 147 have to be addressed every time we have a 40B because it includes multiple structures?
147 requires a builder or developer to obtain a special permit from planning board? Was it planning board?
I believe so.
Requires a special permit from the planning board. Our position is that because this is a comprehensive permit, the authority of those boards is your authority. So that essentially we will not have, we would not, if this is granted, we would not have to go before your planning board for a separate permit. Under 40B, the only laws that we go back for separate permits would be the Wetlands Protection Act and Title V.
I thought it was Board of Health and not Planning Board, but
I could be wrong, but it is a special permit requirement. It's like a standalone permit.
That's the meeting that I would concur that the 40B process funnels all those, original permitting, dialogue, review under.
Well, since the town has no zoning requirement allowing multiple unit development anyway, then it all has to go through the Board of Appeals because that's against the zoning bylaws of the town, no condominiums.
I mean, 147 has a lot of pieces to it, so just taking that all off the table in one fell swoop, I don't know. And we've got everything from the authority of Board of Health and promulgation of regulations, approval of permit, performance standards, right of entry, emergencies, appeals, violations and penalties. So does that waive everything under 147?
I mean, it seems to say here specifically, a waiver requested from SEC to allow for construction and development, which includes multiple duplex structures. So that seems to be the crux of the
Just
waiver.
147 1B? So if it's 147 1B, it's a waiver from, for the purposes of this bylaw, the following activities are allowed without a permit. Application of fertilizers and pesticides in accordance with manufacturer's recommended procedures, non-inject, yeah.
So 1B3?
1B, 1B3, construction of single-family dwellings, okay, so it's just that specifically, that one,
Mhm.
okay.
So-
Okay.
So it's specific to that, you know, that section, then it appears that the board's favorable on that one.
Yeah, I would say, yes.
Okay. So I guess let's then follow the advice of council as far as concluding on a vote for an individual, either in groups or individual, that maybe they're unanimous or they have a split on it, so.
Mr. Chairman,
Mhm.
before you vote, are you, is it your intention to close the public hearing before you vote on those issues, or?
Well.
Because I don't think you've
Well, no.
closed the,
Well, I thought that if we're not closing the public hearing to vote on the decision, it's just to get the, whether the individual responses were favorable or not, you know.
Okay.
I would, again, my impression was that, you know, we come to a conclusion on whether a yes or no, and then we vote on the decision, these are embedded in the decision as a board, whether it be favorable or not. But if you're recommending, because there was some, they weren't all unanimous, that we would have to get that individual voted, I was gonna do that now. But if you think that we need to close the hearing first before we do that or not, so.
it's up to you whether you want to take any further public comment or comment from the applicant before you close the public hearing. Before you take votes, whether you want to close the public hearing before you take any votes.
So, does anyone have any feedback then on the process we just went through, as far as comments and then we memorialize that? Question or no?
Yes.
Yes, you,
Name
name and.
Rhonda Balco, Green Road. I am very concerned about this because affordable housing is supposed to be for the public good. And this is a substantial detriment to the public good because you're making these people under this situation second-class citizens.
These people,
The people that'll be living in the 40B, you're putting them in a precarious situation. And Bolton, the town of Bolton, is going to be the one that's going to be responsible for all their actions in the end. Not the developer, he'll just go away with the money.
they do that, I'll let that stand. I mean, there are provisions, if it were to get permitted, you know, the homeowner association, all those things, and people buy knowing that they're buying a property, you know, so some of it is, you know, they have to do due diligence too. But I understand your point, so.
Bob Martell, 302 Long Hill Road. I want to know why you felt compelled to make a decision tonight. I thought you had some time after the close of public hearing to continue to deliberate and come up with a final decision, and there's still some data points out there, like the Ecotech survey and you know, potentially other feedback from DEP on wetlands delineation, so I was wondering.
So we have a limited window of you know, procedurally from the state to say we have so many, 180 days, right? So we're, you know, to go through this process. Now, we asked for the extension so that we could get to this point of deliberating on, the waivers are a key part of the decision. We have, then once, we have to ultimately make a decision on it, and then we have so many days to, you know, write that decision. So we can't just continue to say, oh, we have data points or we have additional information. At some point, we have a state required to find time, and that's where we're up against. So we can't technically, you know, continue to run this process. So yes, we would have to make a decision on this closed hearing. We could make a vote on it, or we could, but at some point, we have to decide within, you know, short order, correct?
You have 40 days to issue your decision from the close of the public hearing.
And what we have mandated time to close the public hearing based on state guidelines.
Correct.
Right. And that's where we're at. And so,
Is Mr. Peznola here this evening?
well, he has surgery, so he's out.
Because I had several questions for him, and probably the key one of this, and I'm looking at the 40B handbook that the state puts out. And there's, some various guidelines in here that are kind of boiled down for the public. And one of them talks about the decision and, if you decide to approve with conditions. And I just wanted to read this paragraph and, get your comments on that. So it says if the ZBA cannot reach agreement with the applicant, the ZBA needs to ensure that the conditions it plans to impose will withstand a review by the HAC. The decision must have carefully developed findings of fact that are supported in the record by testimony from qualified professionals, peer consultants, and municipal staff. For the appeal to the HAC of an approval with conditions, the developer has the burden of proving that one or more of the ZBA's conditions makes the project uneconomic. Therefore, if you approve with conditions, the onus is back on the developer to prove that you somehow made this uneconomic. If the developer then satisfies this requirement, the burden shifts back to the ZBA to show that the conditions are consistent with local needs, which is, I think, what you've been discussing here. In these cases, and it talks, in these cases, to me implies, in the case where you were to give a condition, approval with conditions, then it's the HAC's duty to balance the regional need for affordable housing with the degree to which the project threatens public health or safety or the environment or is seriously deficient in terms of site and building design or provision of open space. So the way this reads to me is, and it seems to be just a nuance of the law, and what I've gathered looking at cases that have gone before the HAC, it seems like if you're inclined to deny the project outright, then you're less likely to get what you're after in terms of conditions than you are to approve with conditions. And then, you basically have to prove that your conditions are reasonable. So, to me, this is a fine nuance of the law that, I would like to ask Mr. Peznola tonight for his opinion on. And I would encourage the board to, before you make a decision on this, to, consider the spirit of what you're trying to do here and what your best recourse for success is in terms of the spirit of that under the law, the way the law is written.
not being an attorney, do you have any comment on that?
I think those kinds of more nuanced issues as to how the board should kind of frame its decision, and those issues, I think, frankly, are issues for executive session for the board to obtain legal counsel. And I think that's the appropriate forum for that kind of a discussion.
Thank you. Question in the back.
Yeah, Eric Johnson, 436 Still River Road. Following up, I basically have a procedural question. The draft decision, while it's pretty comprehensive and very well prepared, seems to be a one-size-fits-all document, where at the end you're basically given the three options: deny the permit, grant the permit, grant the permit with conditions. I'm curious as to whether or not the board is going to be provided with an alternative draft decision that essentially provides the factual and legal basis for denying the permit. Clearly, the factual statements and the procedural history in the draft decision in and of itself, I believe as an attorney would support the decision, but I'm curious as to whether or not there will be, presumably drafted by town council, an alternative decision which is designed specifically to support the denial of the comprehensive permit, rather than trying to do all things in one document.
That's what we just discussed, right? I mean, that's,
But my understanding is the decision is the board's decision, it's not, right? And so if we had feedback from town council on the structure of it or on the wording of it, that's one thing, but.
Oh, yeah, no, that's.
Not a separate.
Yeah, no, Chairman, that's what I'm
We have a
asking.
secondary decision or opinion that's gonna counter the board's.
Yeah,
My
no,
understanding of it?
I think it's worth emphasizing that there is no decision.
Right.
no, I understand,
Right,
but
so-
there is a draft decision, which, the applicant's been provided, the board members have been providing, and essentially, to a certain extent, the exceptions that you're going through.
But we're drafting it, this is.
Not a decision, just,
That's right. So we're drafting this document, it's not like a third party draft.
Oh, no, I understand. But my question, Chairman, was whether or not you're being provided with the guidance to draft the document before it's actually voted on. In other words, have you consulted with town council to say if we were to vote against this, what would the decision look like? You have a decision in front of you now, which basically would be what it would look like if you issued the permit with the draft conditions enclosed. My question is whether or not, when you vote in executive session, you will have at that time or prepared on your behalf a document specifically drafted to support the decision to deny the permit. In other words, my neighbor here referenced the guidebook, but the statute is fairly clear in terms of when a board can deny the permit. And indeed, if the statute didn't allow for the denial of a permit, it wouldn't. In other words, there are circumstances, and certainly, as you can tell from all of my times at these hearings, I feel that this is one of those circumstances. But certainly, in order to withstand an appeal to the HAC, which has a very high standard, I certainly would hope that if it's the board's decision to deny the permit, that it gets the best counsel it can in order to draft a decision that would withstand the scrutiny of the HAC and possibly support any appeals to the Superior Court.
Agree. And as part of our decision process, we do engage town council's input on the decision, so that will be part of the process, yes.
Thank you.
But that doesn't preclude us from coming to a conclusion on this structure that we have in this draft.
Oh, no.
And then voting on, from a board perspective, okay, so now we have the waivers, we have the procedure history, we've culled the different potential conditions, and, but we have to at some point make a decision whether we want to vote to accept or deny the permit, and then we have to then document that decision within the specified time frame.
Yeah, understood.
During that time frame, we then bring in town council as well to ensure that the document's is correct in some respect, as far as procedural and structure. It's our document, it's our town's document, so we have to make sure it's does the best.
Yeah, again, we all know that, a well-crafted legal document is much more apt to withstand scrutiny by attorneys and bureaucrats than not.
That and the comprehensive record we have too, with it, so it's a company. So. And any other comments?
Just a general question. And I thought this had been brought up in a prior meeting in terms of that we can't talk about a reduction in size of this development. If Mr. Pesnell was here, I'd pose this question to him, but again, as I'm reading through the handbook, it speaks to how ZBAs frequently try to negotiate reductions in size, density of scale, when there are things, that concern like open space and the environment and the types of things we're talking about now. I know the developer hasn't put forth a plan for fewer than 8 units. I know you haven't made any inferences to that end, and maybe you can. but what I'm reading suggests that even the pro forma is subject to review if there's open space planning, design, environmental, safety types of concerns. So, don't comment if you can't, but my question is, why haven't we at all in this process talked about a smaller
I
project?
think we did.
We did, and I
We
think
did
part of
early
the
on.
problem, I think part of the concern is that, some people have asserted, in boards have asserted that at 8 units, you get 2 units of affordable housing and de minimis percentage movement on the town's 10%. So if we were to potentially have a smaller development, at a minimum, you get maybe 1 affordable unit. Is it the same issue that, for
Well, and all
for
these
such a
requests for
property?
waivers go away pretty much if you shrunk things, right? So that's.
Not
really.
not necessarily, not necessarily, because you still have units, and you have, depending on where they're situated, and, so again, I don't know that for a fact that they'll go away. But the affordable house, other projects we've had to scale down the impact, yes, we may have ended up with 6 affordables, 10 affordables, 12 affordables. On this, to scale it down, in private discussion, it's, you get 1 or a fraction of an affordable, so how do you, so it's not necessarily as easy a thing to negotiate. So that was what was discussed in the past, and I think Joe, there's no our peer review would echo that currently, if you were here, but I don't want to disagree.
Thank you.
Okay, so, is that it from the audience? Anything from the applicant, and then we can... So proceed with, Erica, for process-wise, will we then vote for, close the public hearing vote, and then do that discussion on, voting on the individual waivers that we just went through?
Yes, so the board, if you feel that you have all the necessary information, which it sounds like you do, you would want to close the hearing tonight. I don't know that you necessarily need to vote on the waivers tonight. I think it was discussed, but David, do you think that they necessarily need to vote if they want to think about it some more?
That doesn't necessarily approve or disapprove the project, it just votes on the waivers.
Right.
Yeah, we wouldn't do
But we
that.
still have to vote at some point too.
Right. But then that's when we have the time to craft the response. I don't care what they should. Is there any suggestion?
So my reading of it is you're not actually required to issue your decision or vote your decision tonight, but you do have to close the public hearing. So from the close of the public hearing, you have 40 days to issue your decision.
So, I think at that stage, where we should close the public hearing.
Make a move.
Okay.
Motion to close public hearing.
Second favor? Second by Brad. So all in favor of close the public hearing portion? Mary?
Aye.
So if we have 40 days from the first public organization decision, then we have to schedule a hearing if we don't want to do it tonight to reconvene the decision, document potentially.
Well, you want to vote, right? So that you know what you want to put in the hearing. I mean, I guess I would pose this to the applicant too. My view of it is that of the regs is that the board is not required, the board is required to close the public hearing within 180 days, not necessarily vote its decision within 180 days. Right.
The 40-day period is in addition to the 180 days.
Right. So they've closed the public hearing. 40 days from now, they have to issue their decision, which I expect will take place at a subsequent hearing.
Okay. So,
So prior to the next meeting, could we hold an executive session to discuss the approach to the decision? I mean, I think that would be beneficial if we can do that.
Yeah, I think we'll have to,
Talk about that.
you and I will have to.
Okay, okay.
So, calendar-wise, when can the board meet to work on the decision? Oh, no, language.
I'm not available to look at it. Thursday the 18th? I can do that.
Thursday, April 18th? Yeah, Thursday, April 18th.
Vacation, just so you know. On vacation.
Thursday, April 18th. Do you know what time is available?
This room is available.
Oh, so it's 7 o'clock? 7 o'clock.
7 o'clock here on the 18th.
Okay.
I'm sorry, Michael, what was that for?
So the next meeting will be on April 18th at 7 o'clock in this building.
Like the executive session?
No, we'll show up to find out,
Likely.
availability.
So why don't we say that that's the tentative date for the next meeting, and then I'll talk offline with town council, and we'll go from there, because this isn't a public hearing at this point, it's a meeting, so, we only have to post 48 hours prior.
The applicant would just ask that we be notified of the meeting
Of course.
whenever it may
Of
be.
course.
Sure.
Meeting? Okay. All in favor?